Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Bill Mahan, William D. Mahan, who I am just going to call Bill. And Bill is an attorney here in San Jose, California. He's of counsel to Gates, Eisenhart, Dawson, and he's been practicing law, 38 years or so?
Yeah, 37.
37, okay. He has a master's in taxation from Golden Gate University and his JD or law degree from Santa Clara University. And his practice focuses on estate planning and probate and business planning. So, Bill, thanks for joining me today.
My pleasure.
Today is October 25th, 2016, to give you a little reference for where we are, because you're going to see this sometime later. However, this is a sort of a timeless topic in some ways, although some of the things we'll talk about are a little current. And that is, we're talking about why you need a will. And as we get started in this area, I want to caution our viewers to seek legal advice. We are also talking about California law here. Bill is a California attorney. I'm a California CPA. And the rules even vary a little bit around the state, depending on the rules for the local court and so forth. So just be aware of that. You need to get a local attorney to help you out related to this stuff. We don't believe this is a do-it-yourself job.
That's for sure.
Okay. So, Bill, again, thanks for joining me today. So as we get started, any guess about what part of the adult population doesn't have a will?
Well, I haven't actually looked at statistics in a while, but it's much less than half of the adults who could benefit from estate planning actually have any kind of estate planning, a will or a trust or whatever it is they could benefit from. The last time I looked at the statistics, it was about 15%. Hopefully it's improved a bit since then, and it may be better in areas like the Bay Area where, people...
More educated.
Yeah, possibly.
Yeah, and more hustle by the attorneys local.
more advertising.
More advertising. So anyway, so in other words, what's going on is that when people do pass away, you and your fellow attorneys, to a large degree, are sort of picking up the pieces and dealing with intestate estates.
Right. Well, when a person dies, the property they owned, there are several issues that have to be resolved. And the probate court, which is part of the Superior Court, that's the whole function of that department, is to take care of not just the distribution of the estate. It's not just who's going to get it, but how do you clear up things like if there are creditors, how do they get their claims paid, and if the chain of title to property, you have to clear people's name from title. So there are a lot of legal reasons why you have to have a process in place. And for people who haven't done any estate planning, it's called intestacy, and it's going to be through the probate court if they have assets that pass through probate.
Okay. Why do you think people don't get one? Why don't they get a will?
Well, there are a lot of reasons. I always say people don't wake up in the morning and think, I have to get my will today.
I did.
Well, it's possible, but usually there's some kind of a triggering event.
Mm-hmm.
And without that, people, sometimes they don't want to face the reality of their life or their death. Sometimes they don't want to, stimulate any kind of argument or discussion with a spouse or something. They're all different family situations, and it can lead to a little bit of controversy sometimes. But I think the primary reason is it's just procrastination or putting it off. I don't need it today, so I'll wait until I need it tomorrow.
Yeah, I don't need it today, but tomorrow I need it, but then it'll be too late, right?
Sometimes it's too late. I've had that happen.
Yeah. So what are, you mentioned, some events that eventually motivate people to go ahead. What are some of the events that get people thinking about going ahead and putting together a will?
Well, usually there are fairly large events, like somebody, gets married and they start thinking in terms of family. They have children. That's often a motivator, because now they're thinking about, well, what's going to happen to the kids if something happens to both of us? Who's going to take care of them, and then who's going to manage their assets for them until they're old enough? And so people then, that's a primary motivator. Other things are, major events in your health. I get situations, unfortunately, where people are already in intensive care, and that's when they're doing it. But more often, something like a surgery's coming up. And another thing that happens is a lot when people are getting ready to travel and maybe go overseas, and that it will make them stop and think about it.
Yeah. And I guess another one would be just, they have a friend or family member that passes away.
Right.
So,
Or a parent, anything like that where you've seen the consequences of not planning will trigger people to do it.
Yeah. So you and I are both getting up there. We've had our parents pass, and so suddenly mortality is sort of staring you in the face, and I remember when Mom and Dad were this age, with this gray hair and
Yeah,
stuff.
it is difficult to think about, but it seems to be more relevant every day.
Okay, well, again, so why don't you, again, maybe go through some details about what happens when you don't have a will?
Well, when I meet with clients for the first time, I ask them if they have any kind of estate plan, which to me an estate plan is a will or a trust, or sometimes people do planning with how they hold title to assets. But I ask them the question, do they have an estate plan? And if they say no, I say, well, actually you do, you just don't know what it is. It's called the California Probate Code. Mm-hmm. And it covers what happens when a person dies without a will. It's called intestacy. They have to own assets that would create a probate, so they have to have a certain amount of assets and sometimes a certain type of assets. So for example, real estate will almost always create some kind of probate proceeding. Mm-hmm. But if you own assets like real estate in, the title is something like joint tenancy with right of survivorship or community property with right of survivorship, it may not create a probate. Mm-hmm. But, generally speaking, probate is for any kind of asset that doesn't have a beneficiary designation or title such as joint tenancy. Mm-hmm. So real estate, stock, anything like that.
Right. And then also, many people, of course, are getting trusts. They become much more popular, and so the will, in many cases, is sort of a supplement. It sort of goes together with the trust, I guess.
Right. The primary type of estate planning I do for my clients are living trusts, and the advantage of living trusts are quite extensive. There is something called a pour-over will that backs it up, but the idea is not to have that will actually do anything when the person dies, because if you take the assets that would otherwise go through probate and transfer them into the living trust while you're alive, which is why it's called a living trust, then those assets, because they're owned by the trust and not by the individual when they die, they don't have to be probated. And the advantage of that is you don't have to go through probate court. Probate takes about 9 months to a year. Mm-hmm. The probate fees are quite expensive. They're a percentage of the gross asset value, which means that even if there's a large mortgage on the real estate, it's not the net value of the real estate that's the probate value. It's the gross value. Uh-huh. And so the fees can be extensive. The time involved can be extensive. Oftentimes things have to be done through court procedures and court supervision. With a living trust, you don't need that. You have it outside of probate. You are able to deal with the assets through the successor trustees to the trust. And so if you need to borrow money or sell property or even just distribute it to the beneficiaries, you don't have to go through court proceedings unless there's some kind of a dispute or something like that.
Okay. So, if you don't have a will, how do they figure out who the executor is going to be?
Well, again, everything is covered by that probate code. So, as I said, if you have a will, you get to say things like who's going to be in charge of your estate and who's it going to go to. Well, who's going to be in charge with a will is called an executor. If you don't have a will, then the estate is called intestacy again, and you're in probate, and the court will appoint an administrator. So it's a slightly different term, but a very similar job. Mm-hmm. The people that are appointed, frankly, it's the person who applies to be appointed, as long as they have some kind of relationship to the decedent that would allow them to qualify. And then if other people don't agree with that, they can object and they can kind of argue about who should be appointed. But it's done that way. People have to actually file papers with the court and tell the judge this is who should be appointed, and then the judge decides.
He makes the decision. Okay, so what are some things to think about when you're putting together a will related to small children?
Well, as I said before, again, that's one of the main reasons that motivates people to actually do estate planning, because you're concerned about several things. One of them is, they're not really old enough to own property, and they legally aren't even able to own property until they're 18 in California, which is still pretty young. So, with young children, you often want to have something in the will that says who's going to manage the assets for them until they're old enough. So you can do a will, what's called a testamentary trust will, where the trust inside of the will do that, and you name a trustee, and then they can manage for the children. The other really big factor for young children is who's going to have physical custody and control over them and make their living decisions and their healthcare decisions. And, you don't have to do it in a will, but in a nomination of guardian, which could be in a will or a separate document, you can pick your first choice, second choice, third choice for who should be the actual guardian of your children. And the benefit of picking is you don't have to use the same people again that the probate code would first put in line to do that. So rather than your parents or your siblings, you could name other people that you would prefer to have do that with a family home that you thought was the kind of upbringing you wanted them to have. So it just gives you a lot more control over how your children are raised and who makes decisions for them. And the financial decisions and the personal decisions can be separated. You don't have to use the same people to do that.
Right. So in many cases, you may know somebody that's good at handling money, but they may not be so good at handling kids.
Right.
But you may have somebody that's really good at handling the kids and not so good at handling the money.
Right.
So
plus they can kind of watch each other a little bit, which is good as well.
Yeah. But related to this business of naming the guardian, I think for many people, because even with modest estates, that would be, I would think, to them, maybe even the most important thing that they have in the whole document.
I think for people with young children, it is the most important thing.
Yeah.
You want to know, that the people who are raising your children, that they're going to have a happy home, and the things that go along with being a parent. And I think most mothers and fathers would like to choose the people who, of course, they should talk with beforehand before they actually make the nomination. But that's something they really find important.
Yeah. I had one couple, and they said, we just have a really hard time with this. We can't think of anybody else. I said, well, you're just going to have to live then,
Yeah.
And fortunately, they did, so it's okay. So what can you do with a will aside from naming an executor and a guardian for the kids?
Well, I mentioned before that there's a type of will, it's called a testamentary trust will. Mm-hmm. So you can actually establish a trust inside of a will. I don't know if this is what you were asking about, but by doing that, and it doesn't have to just be for children, it can be for anybody that you think needs the help of a manager who would be your beneficiary. It'd be a brother, a sister, even an elderly parent. You don't have to give them the property. You can give the property to a trust for their benefit, and then decide within the terms of the trust how much they get, if they get income and principal, or if at some point in time they get an outright distribution and actually get to own the property. You can decide all of those things, just like you can with a living trust, but you can do it inside of a will. So why would you do it in a will rather than in a living trust? Well, some estates aren't really large, and families are young and just getting started, and so for reasons of economy more than anything else, they'll do a testamentary trust rather than a revocable living trust.
Right. And of course, there are other, there are basic things. You can give property. You can say, I want my mom's wedding ring will go to my daughter. Right.
The who gets it and when, who gets what and when is part of what's in a will, and so you can specify, to some significant degree, who gets exactly what, the silverware and the jewelry and all that kind of thing. Yeah.
All right.
And also you can specify your burial instructions. If you want to be cremated, you should say so. Things like that.
Yeah. Now, related to that, I dealt with quite a few situations where they didn't look at the will until after the person was
After they
After
died?
the funeral. In one family, they said, yeah, she said she just wanted to be cremated and scattered at sea, but we had a really gorgeous, it was the most beautiful funeral
Yeah.
you ever saw for her.
Well, yeah,
She probably would have been really mad if she knew about it, but anyway.
yeah, the good advice there is you should also tell people what your wishes are, not just write it in your will.
Right. And another thing, of course, is if you want to disinherit somebody,
Right,
which
right.
isn't a pleasant thought, but for some
Right.
people this is an important consideration.
Yeah, and it's a tricky thing to do. People oftentimes will disagree with your decision to do that, and so it can create stress and litigation. But if that's what a person wants to do, if it's done correctly, it usually works. It usually, I mean, there's no reason why it shouldn't work. Sometimes people would rather settle a case than fight about it, but people should be, it's called your will, and you should be able to do what you want with your property.
Some people say that a good tactic, especially for people who are very wealthy, if they're going to do something like this, is not to totally disinherit them, but to give them sort of a modest inheritance, so
Well,
that then they have something to lose if they decide to contest.
Right. In the olden days, they used to give $1 and think that really is sort of irrelevant. It wouldn't mean anything. But if you give them something to lose, the point is that if you say that somebody gets nothing, they have no incentive not to contest if they want to, because they aren't going to lose anything. If the thing about a contest, if you contest a will or a trust and you lose, you often get nothing because of something called a no contest clause. But if you have nothing to lose, then there's no disincentive other than the cost of hiring lawyers. Whereas if you actually gave them something modest, but significant enough to make them think about it, then that might prevent them from contesting. Mm-hmm. So it depends on how large the estate is, but basically I think people should be able to do what they want as long as they have the ability to make their own choices.
Mm-hmm. Okay. What are some thoughts about adult children and children from previous marriages?
Well, anytime you have a family that consists of multiple marriages and children from previous marriages, sometimes that's not a problem. Oftentimes it is a problem, because you have, people that the sequence in which they die can affect what the children from the predeceased spouse will receive. And there's a much higher likelihood that there's going to be some unhappiness and some maybe arguing or litigating over estates. And there are some things you can do to try to mitigate that. Trusts, again, help. We're not talking about trusts here today, but they help because you have a way of holding property in a trust after you die and dealing with it, later at the second death. But if short of that, you can do certain things. Often, if there's a surviving spouse, you wouldn't want to give away the estate to the children from a previous marriage, because that may leave not enough for the surviving spouse, to have on their normal life. But you can do things like, maybe buy some life insurance if you're insurable, and set that up in such a way that children from a prior marriage, depending on who dies first, that those children would get something from life insurance that's separate and apart from the other part of the estate that you need, like the house and the furniture and all that. Mm-hmm. So planning like that can be done and can be helpful.
Right. And even when you have adult kids, well, one, they're in suspense until the surviving spouse, maybe your mom or dad, passes away, and what if mom or dad, remarries or something?
Right. Well,
then that creates other conflicts. So, in some cases, it might, again, especially if you're substantial, you might do well to give some property, to your adult kids.
Yes, and sometimes, well, there's other reasons for doing that if the estate is large enough, but through gifting or through some transfer of death, by bypassing a spouse and leaving property to adult children, that's part of estate planning. Is also part of tax planning and things, various things that you're thinking, so that you're not only avoiding the problem of what happens if their spouse remarries, but leaving everything to a surviving spouse and then having that estate become too large if the estate tax credits don't cover it or whatever.
Okay.
So there's planning involved in all of that.
So do you have other thoughts about the second marriage situation when you're doing this estate planning?
Well, anytime I have people who are, married for multiple times or contemplating remarrying, I talk to them. I ask married couples who come to see me, even if it's the first time, if they have any kind of prenuptial agreement, because people oftentimes bring property into the marriage that is their separate property, and it won't necessarily remain separate property without some kind of an agreement. So it's important to know that, whether they have one, and also to discuss it to see if they would like to have one and would benefit from having one. They work, but they have to be done properly, and it usually involves multiple attorneys, one for each spouse, because of the way the laws work with a postnuptial. You can do a prenuptial, which is before you're married. You can do a postnuptial after you're married. Yeah.
Okay, and in many cases I understand that people actually suggest in this type of a scenario, especially again if both of them have significant property, that each of them should have their own attorney related to the estate plan.
You pretty much need to. I mean, you can actually sign waivers saying that you decided not to, but to make it really enforceable and to make it fair, especially to a spouse that has more assets, one more than the other, you should have independent counsel because these things are covered now by statute, and the statutes basically expect there to be multiple attorneys unless, if somebody absolutely refuses, then the option is to have no agreement or do it without two attorneys, and so you can still do it without two.
Yeah. And related to all of this, it's good to have some conversation that's going on, hopefully good communication within the family and so forth. And
Right.
if you have good relationships, that may help to reduce problems later.
Right. And, well, communication in the family is important, but there can be good communication and bad communication. So the kind you're talking about is good communication. Bad communication happens when people more or less promise things that then they don't actually follow through with. So, I also don't believe in planning by committee. I think, the people, the parents should make the decisions.
Yeah.
But you shouldn't do things like pick successor trustees or guardians or people to make your health care decisions and never talk to them about it, like your client who found out after the death that there was a cremation provision. You don't want to do that. You want to have some conversation about what the plan is.
Okay. Could you be hurt tax-wise if you don't have a will or trust?
Yes. There is tax planning that can be done with both wills and trust. The primary one that we deal with in estates is the estate tax, but the credits now are much higher than they used to be. They're up to $5,450,000 this year, and they'll probably go up again with increases in cost of living or whatever. And so that's a very significant estate because it's per person, and so a married couple can now have like $10.8 million without estate tax. So that kind of concern is gone for the vast majority of people. But you still want to, make sure of things like basis adjustment for income tax purposes, and there's different kinds of taxes we deal with. There's real property taxes. There's potentially change of ownership when a person dies. If it's a parent-to-child transfer, there wouldn't be, but those things have to be processed through the assessor's office correctly, and so there are certainly tax implications to a person dying that may or may not necessarily have to happen, but sometimes they can happen if things aren't handled correctly.
Okay. Where should you keep your will?
Well, I think they should be kept in a safe deposit box. It used to be difficult to get in safe deposit boxes after people die. It's not so much a problem now. But I think that primarily so if your house burns down, your estate plan doesn't burn down with it, and I've had that happen. People keep them sometimes in a safe at home. That's okay. They're not necessarily as fireproof as people think they might be either. And you have to keep in mind, who has access to your estate plan as well. Unfortunately, sometimes the estate plan will disappear, after a person dies, and there's reasons why that would happen if the person that found it didn't like what it said. So you need to be a little careful about where your plan is kept and who has access to it. I think the best place is a safe deposit box, and then let the person who's going to take charge of your estate be the one who has the access if you're gone.
Yeah. One attorney that I heard speak at one time said, I like it in the safe deposit box because then it's not available for people to doodle on.
That's true too. They'll write on them.
People will tend to make notes and then suddenly they've invalidated their will. There it goes, poof. Well, we're basically out of time. Do you have maybe some final thoughts that you'd like to throw out as we conclude this thing?
Well, as you said at the beginning, it's important, I think, to get advice on this. There's a lot of do-it-yourself and internet stuff where people try to do these plans themselves. It's even sometimes lawyer-prepared estate plans, if it's done by an attorney who doesn't do a lot of estate planning, it doesn't really help that much. It makes things sometimes worse. So doing it yourself is not a good idea, and it's a good idea to get advice in the jurisdiction where you live. Certainly outside of California, you'd want to go to an attorney where you live, and even in California, probably some benefits to going to somebody local as long as they are experienced and qualified.
Right, yeah. Familiar with local rules, all that stuff, and with the developments. I mean, just imagine you and I were in a time warp, and so we had to do estate planning, and we knew what we knew 10 years ago, but now we have to deal with what the law is now. I mean, it just wouldn't make any sense. It doesn't work.
Right.
So you do need to get your plan even reviewed from time to time if you have a will. And actually, there have been recent developments, as we said. So if you haven't seen your attorney, I would say in the last couple of years, it might be worth making a visit. In fact, there's a quite recent one that we talked about, where this thing that's called a Q-tip election, and now we have a portability election, and you can use them together in special ways for benefits for your family. So you should see your attorney related to things like that. Folks, we're all out of time. See you next time on Financial Insider Weekly.